which appears likely to uphold two state laws banning transgender girls from competing on girls' sports teams. Justices hearing arguments today in a pair of cases, one of them pitting transgender teenager Becky Pepper Jackson against the Republican Attorney General of West Virginia. The court's decision could ultimately decide whether Pepper Jackson and other trans girls and women are allowed to play in girls' sporting events. Justices are now weighing claims of discrimination by transgender people versus concerns over fair competition. Let's bring in ABC News legal contributor and Hofstra law professor James Sample. So James, let's just get right to it here. How do you think the Supreme Court, with its conservative majority, will rule on these bans?
Elizabeth, great to be with you as always. I think that the tea leaves here are pretty clear. It's rare when you can listen to a Supreme Court oral argument and be confident in a prediction, and sometimes speculating can be dangerous. But in this particular context, I don't think there's much question that the bans in Idaho and West Virginia will be upheld. There are 25 additional states in addition to Idaho and West Virginia, the two states that were at issue here, that have similar bans in place. I think the real question after oral argument, it comes down to whether or not whether or not the bans will be upheld. I think they will, but whether or not the rationale for upholding the bans will be a rationale that requires states who do not currently have a ban in place to also have an effective ban in place, or whether the states will be free to make their own decision, as 23 states have done, to not impose a similar ban.
Right. So based on how the court rules here, this could impact a lot more than who can participate in girls and women's sports. Talk to us a little bit about what's at stake on the state level.
Sure. So, the high water mark for trans rights at the Supreme Court really came about 5 years ago in a case called Bostock. That dealt with a different provision of the Civil Rights Act. Title IX is the provision that applies to girls and women's sports and to sports generally. Title VII is the provision that deals with the employment context. And in that context, the court said that there needed to be protections, that discriminating against workers, against employees on the basis that they were transgender was a violation of Title VII. But this case, which deals with sports, if the court rules quite broadly, it won't impact the Bostock ruling, but it might impact other contexts in which we have essentially sex-segregated spaces. So restrooms, locker rooms, certain contexts where we have historically, and states have historically, divided things up on the basis of sex, what to do then when you have a transgender individual. In sports, there is a strong argument to be made for competitive balance, for competitive safety, but in other contexts, will the rationale endanger transgender individuals in those contexts?
Yeah, really big implications there. Before this interview, James, you said, before this, you said that the argument could be a microcosm of the debate between, quote, original intent and originalism. Explain what you mean by that.
So, Elizabeth, good question. The court majority, the 6-3 majority that we often hear so much about, has been borderline obsessive over the last decade and a half with regard to originalism, the idea of what the individuals who, in the case of the Constitution, the founding fathers meant when they wrote a provision, or in the case of legislation like Title IX, what the individual legislators and the president who signed it into law meant when they signed it into law, or more conversely, whether or not those meanings can adjust over time. In this context, I think both of those arguments will end up playing out in favor of the states.
Our legal guru, James Sample, thank you so much for always teaching me something, James.